Hi, I'm Natalie and I'm inquiring at Ridley and Hall today about buying a property. The main thing is that I'm buying with my partner and we're also first time buyers. So I'd like to know a bit more about buying a property and what I need to do, and also whether there's anything legally I need to do, seeing as I'm putting in 60% of the deposit and he is putting in 40% of the deposit.
Hi Natalie, I'm Shad and I'm a property solicitor at Ridley and Hall. So you've got a few options on what you can do. The first is you can look at holding the property as joint tenants. Joint tenants means that you and your partner would hold the property equally. If one of you were to pass away, the other would inherit the property through survivorship. So that means that if you're looking to make anything like a will, it does complicate matters for you a bit more. And if you're doing joint tenants, you obviously have to take into consideration if you're paying more of a deposit, you don't have any protection in that regard. You've paid that deposit and that's it. You own the property 50-50. The other option you've got, which is what some clients tend to take when they're putting more of a deposit than the other person, is they hold the property as tenants in common. Tenants in common is a way to hold a property which allows you to make provisions for it, for example, in wills and what's called declaration of trusts as well. If you hold a property as tenants in common, you can hold it in equal shares or you can hold it in unequal shares as well. So for example, the fact that you're putting in 60%, you might want to own 60% of the shares of the property and your partner owns 40% of the shares in the property instead, to reflect the different amount of money you've put in. That might be some arrangement you come to. What might be a consideration for you is entering into a declaration of trust. Declaration of trusts are legally binding documents that you'd enter into, and you'd set out clauses in there. For example, if you paid £10,000 of the deposit, you'd say you get the first £10,000 of the deposit. And then if your partner paid £5,000, you'd get the next £5,000 of the deposit. So it does allow you to make provisions in there. And what would happen is you'd get the 10,000, he'd get the 5,000, and then the rest of the equity is split 50-50, for example. So it's really important to think about a declaration of trust, because you can put a restriction on the property, which does state that the disposal, the sale of the property must take place in accordance with that declaration of trust. So when you come to sell it, another solicitor will see that and they'll know that there's a declaration of trust that they need to look at and make sure that they follow in order to remove that restriction. So I'll let you ask Vicky any questions you've sort of got, then we can go from there.
Thank you, Shad.
Yeah, thanks, Shad. Hi, Natalie. My name's Vicky. I work in our family team as a trainee solicitor. Firstly, congratulations. It's very exciting buying your first property. But I think it is really wise that you're asking these questions and thinking about it now before you buy the property. As Shad touched on with regards to holding the property as joint tenants or tenants in common, if you were to purchase the property as joint tenants, so it's assuming that you own the property sort of 50-50, without any evidence otherwise, such as the declaration of trust saying that you don't own it 50-50, we would really strongly recommend getting a cohabitation agreement, because otherwise if you do split up and then you want to later down the line say, oh, hang on a minute, I put in X amount more than you did, without having what's called a cohabitation agreement or your declaration of trust, when you are the joint tenants, it's going to be really difficult for you to prove otherwise, that you should be entitled to having the greater share come back to you. So therefore we do recommend what we call a cohabitation agreement, which basically sets out what you both agree at the start. So it can say, for example, if you were sadly to split, that you get X amount back and your partner gets his X amount back out of the deposit. We can also include in there things such as assets in the house, such as furniture. So if you have a grand piano, for example, that you want to ensure you get back to you, we can put that in the cohabitation agreement. So it goes that one sort of deeper level than just the property side may touch on. And whilst a cohabitation agreement isn't legally binding because it doesn't go before a court, it does carry some weight because it shows obviously what your intentions were when you first got together. So we really would recommend getting a cohabitation agreement.
Perfect. Thank you for your advice, and I'm sure I'll get back to you in instructing you.
Lovely. Take care. Bye.
Thank you. Bye.